Most people think trusts are just for the ultra-wealthy. But the truth is, a revocable living trust can protect anyone who wants to avoid probate, maintain privacy, and make life easier for their loved ones. If you own a home, have minor children, or simply want more control over what happens when you're gone, this tool might give you more control than a will. In this video, I'll break down everything you need to know about revocable living trusts, including what they are, who should consider one, benefits compared to a simple will, potential drawbacks, and common legal terms you should understand. You don't need to be rich to need a trust, just ready to protect what matters most. If you're interested in learning more about wills, durable powers of attorney, or advanced healthcare directives, I've made more in-depth videos on each of these topics. I'll share links to those videos in the description below. A revocable living trust, also known as a living trust or a revocable trust, is a legal arrangement where you, the grantor, place assets into a trust to benefit yourself during your lifetime, with the remaining assets seamlessly passing to your designated beneficiaries upon your death. The primary benefit of a revocable trust is its flexibility. As the grantor, you have the power to modify or completely revoke the trust in response to life changes such as financial shifts, changes in family dynamics, or personal preferences. This adaptability gives you full control over the management of your assets throughout your lifetime and their distribution afterward. Another benefit of placing your assets in a revocable trust is the ability to bypass the probate process. Probate can be a lengthy, public, and expensive process that involves the legal validation of a will and the administration of an estate under court supervision. A revocable trust circumvents this process, enabling a quicker, more private transfer of assets to your beneficiaries. Formal requirements for a revocable trust vary from state to state. However, there are some general similarities among the states. The grantor must have the legal and mental capacity to form a trust. This means the grantor must be of sound mind, fully understanding the nature and consequences of establishing the trust. This includes the ability to comprehend the significance of the assets being placed in the trust, who the beneficiaries will be, and the powers and duties assigned to the trustee. There must be a clear and explicit intention from the grantor to create the trust. This intent is usually formalized in the trust document itself, which acts as a declaration of the grantor's wishes. The document must unequivocally indicate the grantor's desire to establish the trust and govern the distribution of their assets according to the terms set forth within. The trust document is a critical legal instrument, often referred to as the trust agreement or declaration of trust. It outlines all the terms of the trust, including the identification of the trustee and successor trustee, detailed beneficiary designations, and explicit instructions for the management and distribution of the trust's assets. The document should be comprehensive and precise, leaving no ambiguity about the grantor's intentions and how the trust should operate. For the trust to function as intended, it must be properly funded. This means the grantor must transfer ownership of assets into the trust, a process known as funding the trust. Assets can include bank accounts, stocks, real estate, and other personal property. This step typically involves retitling the assets in the name of the trust, which may require filling out and filing specific forms with financial institutions and government bodies. Creating a revocable living trust is a prudent consideration for many different types of people. Individuals who own real estate, whether it's a primary residence, vacation home, or rental property, may benefit from a revocable trust. For those with young children, a revocable living trust can provide specific instructions for the management and use of the assets for the children's care and education in the event of the parent's untimely death, ensuring that their future is secure. Anyone interested in streamlining the inheritance process for their beneficiaries can use a revocable trust to avoid the time-consuming, costly, and public process of probate. Individuals who value privacy and wish to keep their details of their estate and beneficiaries confidential should consider a revocable trust. Unlike a will, which becomes public record during probate, revocable trusts remain private. For those who have blended families or those that wish to disinherit family members or have other unique family circumstances, a revocable trust can provide the discretion and control needed to distribute assets according to your wishes. For those who have specific instructions about how certain assets should be distributed or used, such as maintaining a family home as a gathering place for generations, a trust can ensure those wishes are fulfilled. Individuals who want to ensure that their assets are properly managed in case they become incapacitated due to illness or injury can appoint a trustee to manage their affairs without the need for court intervention. Owners of small businesses or those with significant business interests can use a trust to manage the transfer of their business assets or operations smoothly and according to their wishes. While a revocable trust offers numerous benefits, it also comes with several disadvantages that are important to consider. First, the initial setup of a revocable trust can be more complex and costly than simply drafting a will. Additionally, for the trust to be effective, ongoing management will be necessary, including the proper funding of the trust by transferring assets into it. There's also the ongoing responsibility to manage and maintain the trust, which can be daunting for individuals without financial or legal expertise. Furthermore, a revocable trust provides no tax advantages. The assets in the trust are treated as though they belong to the grantor for tax purposes, including being subject to estate taxes. Lastly, while a revocable trust offers privacy and avoids probate, it does not provide protection against creditors during the grantor's lifetime, which can be a significant drawback for those seeking asset protection. Now that we've outlined the basics of what a revocable trust is and why it's an important estate planning tool, let's explore some of the common terminology related to a revocable trust. Grantor, settlor, and trustor are interchangeable terms that refer to the person who creates the trust. The beneficiaries are the individuals or entities designated by the grantor to receive the trust assets after their death under the terms specified in the trust agreement. The trustee is the individual or institution appointed by the grantor to manage the trust assets according to the trust agreement. The trustee has a fiduciary duty to act in the best interest of the beneficiaries. Initially, this is often the grantor, who then appoints a successor trustee to take over upon their incapacity or death. The successor trustee steps in to manage the trust when the original trustee is no longer able to serve due to incapacity, resignation, or death. This is typically a spouse, a family member, trusted friend, or attorney. A co-trustee is an individual who is appointed to work jointly with one or more other trustees to manage and oversee a trust, sharing the responsibilities and decision-making involved in administering the trust assets according to its terms. Incapacity is a state where an individual cannot manage their affairs, with provisions within the trust to manage this scenario. A fiduciary is a person or entity with a legal obligation to act in the best interest of another. Revocable indicates that the grantor can modify or revoke the trust at any time during their lifetime, as long as they remain mentally competent. When a trust becomes irrevocable, usually upon the grantor's death, it can no longer be altered or revoked. A pour-over will ensures that any assets not included in the trust are eventually transferred into it upon the grantor's death, allowing for cohesive estate management. While I always recommend speaking with an attorney for complex or highly personal situations, an attorney isn't always necessary. That's why I've partnered with trusted names like Trust & Will, Nolo, LegalZoom, and Rocket Lawyer to make estate planning more affordable and accessible. You'll find those affiliate links below, and using them helps support this channel at no extra cost to you. These online tools allow you to create essential legal documents from home, quickly, affordably, and on your schedule. Take control of your future. Start creating your revocable living trust today.